My name is Kristin Slonski. I'm the Director of Advocacy and Legal Services at Judicare Legal Aid, which provides civil legal aid for people residing in the northern 33 counties of the state, plus tribal lands all throughout the state. Well, I work with a lot of newly licensed attorneys in my job with Judicare, and so we've kind of developed some internal trainings along the lines of like, what did law school not teach you? And I feel pretty passionately about providing mentorship to young attorneys, in particular young attorneys who might be willing to do some pro bono work for me in the future. Yeah, so I think one of the things that we don't necessarily know right from the beginning of practicing law is how difficult it can be to take a client's story and present it in a way at trial that's both easily digestible to the trier of fact and also admissible under the rules of evidence. Our clients come to us, they know the story from their point of view. They think they know the story from all points of view. But really when it comes down to taking that story apart and putting it back together again for someone who is not steeped in it, it can be a lot more time-consuming, difficult, and expensive than young practitioners maybe are ready for. Well, absolutely the first thing they should do is familiarize themselves with the rules of civil procedure and the rules of evidence. You don't necessarily have to live and die by those, but they should always be somewhere in the back of your mind. When you're speaking with a client, when you're speaking with a witness, when you're looking at a document, in the back of your mind, you should always be wondering whether or not you can get this admitted and for what purposes. Well, both my co-presenter and I highly recommend from the beginning going to the jury instructions for whatever type of case it is that you're trying. Or if it's a statutory cause of action, going to the statute and looking at the elements that for the jury in the jury instructions and in the statute, those elements will usually be broken out into pieces. And you can take those pieces and write notes to yourself about what witnesses you have to provide that evidence, what those witnesses are going to say, what documents you might have, how you're going to introduce those documents. And you can really identify your the holes that you have in your case, or conversely, the holes that the other side has that you as a defense attorney can exploit. So I write out everything. I script it out like it is premiere television and it's going to be on HBO. I write out the questions I'm going to ask, the answers I think I'm going to get. I write out what witness I'm going to use to introduce what exhibit. I write out to myself to remember to ask that the exhibit be accepted into evidence, because I always forget that part. I write out everything, and then I don't necessarily need it. The act of writing it out has helped me, it's calmed me, it's focused me, and having it in front of me is like a security blanket. If I know that if I do panic and I forget my very name, I can look down at the piece of paper in front of me and be like, oh, it's Kristin Slonski. Woo, and then I can make a little check mark by it. Oh, got that. It's also a good way to make sure that you haven't missed something that's going to be categorically important. You need to make sure that if you need to prove a certain element and you need to ask a question and elicit an answer that proves that element, you need to be able to check that off. So I like having it all written out. So Prepping the client for the case and prepping the client for trial, I think, are two different skill sets. Prepping the client for the case involves really being honest with the person about what litigation is going to entail, right? It's time consuming, it's stressful, it's not there's no guarantees. You need to be honest with your client about the holes that might come up in their story, or the deficiencies that you might have in their case, or how likely, if you're the defendant, how likely the plaintiff is to win, all with a goal towards, like, maybe we should settle this, what would be a decent settlement opportunity. If you're beyond that and you're going to trial, then it's all about reassurances. So what I do with my clients as part of the trial prep is, remember I told you I script everything out, right? Including what I believe their answer is going to be. And when I'm doing trial prep with them, I'll ask them those questions. And if their answer is different, I'll change my expected answer and do the necessary follow-up. But I let the client know that I've got their anticipated answer in front of me. So if they blank out, and a lot of them do, what is your name? And they're just like, I can say, it's Peter Kramer, is that correct? Right? I can give them a little bit of a lead and they can just go, oh yes, that's right. Whew. So I let them know I'm there for them. I'm a backstop for them. They don't have to worry about remembering everything off on the fly. I'm there to lead them through the testimony that I expect to elicit, just try to calm them down. So my first job out of law school was working for a judge. So I've seen this from the other side, and that is that practitioners and the litigants themselves, they've been steeped in this world for so long that they sometimes forget that not everybody has the background, right? Not everybody knows who you're talking about when you're talking about Sheila or when you say her. So I try to always remember that when I'm setting up for trial. This person that I'm telling the story to doesn't have any background, right? So I need to lead them to the relevant background without boring them with, details that don't matter. Most of the time, human psychology being what it is, we understand a story in a very linear fashion. And so starting from the beginning date and walking through is often a good way to organize for trial because people can follow along with that. But sometimes your story doesn't work that way and you need to kind of establish the important facts first and then back up and give some background. But I would say the most important thing is to be intentional about that. Don't find yourself going, oh, whoa, wait, back up. That's the kind of thing you do in conversation with somebody, but it should not be the kind of thing that you do when you're presenting to a judge or jury. Boy, that's a real good question. I mean, to a certain extent, at that point, it's out of your hands. You can always still settle right up until the time, and even after the time of judgment. It's just that your settlement, your negotiation position changes pretty radically in that time. But a lot of times you just have to remind yourself that you prepared and you presented the best case that you could. And now at this point, if things don't go your way, it's because the trier effect was stupid. Yeah, we talked about this a little bit in the panel discussion. You should always, as a young lawyer, you should know what the potential causes of action are and what the statutes of limitations are on those. It's a huge red flag if someone comes to you literally on the eve of the statute of limitations running up. It's going to make your job exponentially harder, and you really kind of have to question how easy is this person going to be to work with. They seem kind of flighty. And along the same lines, you know, if you're working for the defense and someone says, well, I got this summons, 20-day summons 19 days ago, and I really need you to like provide this answer right now. It makes me wonder, are they going to do the homework that I need them to do? And in civil legal aid, which is what I do, I rely on my clients to do a lot of their own homework, because while my services are free, the services of expert witnesses, court reporters, process servers, those things are not free. So in order to keep costs down for my client, I'll often ask them to do some homework. I'm going to ask you to get these medical records that belong to you. I'm going to ask you to stop at the police department and pick up the police report. All of these things, if they're not willing to put in that kind of homework, then I know that they're not going to be so easy to work with on the stand either. I guess the number one tip is to remember that our profession is designed and supposed to be collegial. And that means that it doesn't make you a better lawyer to be a jerk to the other side. The time is going to come when you're going to want to reach out to that person for a favor or for mentorship, and vice versa, that someone's going to come to you. So maintaining that collegiality within the profession, I think, is really important. There's a lot. I would say, in addition to reaching out to people for mentorship, don't be afraid to ask people if they have templates that you can use. Don't be afraid to look to the Wisconsin Courts website for form pleadings. All of those things are designed to be helpful and to help you present what you need to the trier of fact, whether that's the judge or the jury. So it's not cheating, it's not, taking a shortcut, it's acting smarter.